This hearing on the Committee of the Judiciary Subcommittee on Commercial and Administrative Law will now come to order. I will recognize myself for a short statement. This past May, the subcommittee conducted an oversight hearing focusing on the implementation of the 2005 amendments to the Bankruptcy Code. Critics noted that these so-called reforms were particularly problematic with respect to how they impacted consumer debtors. Bankruptcy, which once served as a safety net for the honest but unfortunate debtor, is now a minefield, as exemplified by the 2005 amendments, new means testing and credit counseling requirements. To satisfy the means test, a Chapter 7 debtor must now complete Official Form 22, consisting of 57 sections. This complex form requires the debtor to supply extensive financial information and supporting documentation. And even the GAO found that while credit counseling was generally a useful tool, there were several shortcomings regarding the implementation of the creditor counseling requirement. We are putting people through a bureaucratic maze which they are trying desperately to regain their financial footing. This is why Congressman Brad Miller and I, as part of our legislation to address the subprime mortgage crisis, included provisions alleviating some of these barriers to the bankruptcy process. As highlighted at our hearing in May and subsequently underscored at a hearing in the subcommittee held last month, recent developments in the subprime mortgage industry have brought to light additional problems. After being lured into easy mortgage refinancing arrangements with teaser interest rates, more and more American homeowners find that they are unable to make their monthly mortgage payments. As a result, many attempt to enter into bankruptcy to avoid losing their homes through foreclosure. However, the new rules prevent many of them from doing so because of the difficulty in navigating the bankruptcy process. According to a recent survey of bankruptcy attorneys by the National Association of Consumer Bankruptcy Attorneys, 81% agreed that it is more difficult for people facing foreclosure to obtain bankruptcy relief since the 2005 amendments were enacted. There may yet be another contributing factor to the problems presented by the 2005 amendments. Earlier this year, the Appropriations Committee expressed concern that the United States Trustee Program is expending excessive resources to dismiss consumer bankruptcy cases for insignificant filing defects, and that as a result of these efforts, the program was imposing additional burdens on the judicial system and debtors. The committee also asserted that the program was making burdensome requests for debtors to provide documentation that has no material effect on the outcome of bankruptcy cases. Such actions, according to the Appropriations Committee, are making the bankruptcy process more costly and therefore less available for those who truly need it. More importantly, the committee recommended reducing the program's appropriations by approximately $30 million. These are very serious allegations by the Appropriations Committee, particularly in light of the fact that it plays a primary role in controlling the program's purse strings. In an effort to help us get to the bottom of these allegations, I sent a series of questions to the Executive Office for United States Trustees last August. Copies of those questions and the answers, which were received yesterday evening, are included in your hearing materials. It is my hope that today's hearing provides an opportunity for us to get to the bottom of these allegations. As you know, the Commercial and Administrative Law Subcommittee has primary jurisdiction for the program. Accordingly, if there are any legislative reforms that we conclude are necessary as a result of today's hearing, I intend to recommend them to the full Judiciary Committee for its consideration. I very much look forward to today's hearing and to receiving testimony from all of our witnesses. At this time, I would now like to recognize my colleague, Mr. Cannon, the distinguished ranking member of the subcommittee, for his opening remarks.
Thank you, Madam Chair. I would like to submit my full written statement for the record, but make a couple of comments at the outset. In the first place, we've talked in many of these hearings about how bankruptcy is complex. The fact that it's a maze, or can be characterized as a maze for a debtor, is not inappropriate given the benefits that come out of the process. The question for our committee is, are we making reasonable requirements, and how is that being implemented? It was my policy as chairman of this committee, and it continues to be my policy in support of the chair of this committee, to assert our jurisdiction directly. And I think the nature of the Appropriations Committee and their actions, whatever they may be, are not well-founded because they don't have the understanding of the program that this committee has. So I find their conclusions remarkably unpersuasive, and to the degree they've drawn conclusions and wielded the political bat of an appropriation process is not very meaningful to me. And in fact, I hope that what we do here is push back with clarity, and that doesn't mean that I'm taking any side on this issue. We worked very hard to come to a balance in the Reform Act, Bankruptcy Reform Act, and I want to know if those things worked. We had questions on both sides of the aisle. It was bipartisan, and it's complex. And so I think the point here is what's working, what's not working, how do we make it better, and to the degree that the appropriators disagree, let's help them get educated on the issue. Thank you, Madam Chair. I yield back.
I thank the gentleman for his opening statement. Without objection, other members' opening statements will be included in the record. Without objection, the chair will be authorized to declare recess of the hearing at any point. I'm now pleased to introduce the witnesses for today's hearing. Our first witness is Clifford White III. Mr. White is the Director of the Executive Office for United States Trustees. He served in the federal government for 27 years, including previous service as an Assistant United States Trustee and a Deputy Assistant Attorney General within the Department of Justice, and as Assistant General Counsel at the U.S. Office of Personnel Management. Mr. White was recognized with the Presidential Rank Award for Meritorious Executive in 2006 and the Attorney General's Award for Distinguished Service in 2003. Welcome, Mr. White. Our second witness is the Honorable J. Crystal. In 1985, after 25 years of law practice, Judge Crystal left his position as senior partner in a firm he founded to accept an appointment to the federal bench. He serves as Chief Judge Emeritus in the Southern District of Florida. Prior to his appointment, he served as Special Assistant Attorney General of Florida during the 1959, 1961, 1963, and 1965 sessions of the Florida Legislature. Judge Crystal is an adjunct professor teaching at the University of Miami School of Law. Welcome to you. Our third witness is the Honorable Eugene Wedoff. Did I pronounce that correctly? Wedoff, pardon me. Judge Wedoff was appointed for a 14-year term of office and continues to serve the Bankruptcy Court of the Northern District of Illinois. He is the co-chair of the American Bankruptcy Institute's Consumer Bankruptcy Committee and the associate editor of the American Bankruptcy Law Journal. We want to welcome you. Our fourth witness is Paul Uehara. Is that, did I pronounce? Can you pronounce that? Uehara. Mr. Uehara is a senior staff attorney in the Language Access Project of Community Legal Services Incorporated in Philadelphia, where he focuses on language rights advocacy, improving program accessibility for language minority clients, and representing limited English proficient clients with consumer problems, particularly mortgage foreclosure and bankruptcies. Mr. Uehara has over 25 years of experience at Philadelphia Legal Assistance, CLS, and Delaware County Legal Assistance, both as a paralegal and a lawyer. Mr. Uehara also worked as an assistant city solicitor for the city of Philadelphia and a law clerk in the Federal District Court. Thank you for being here. Our final witness is Mary Powers, the rose among our panel. Ms. Powers is a former trial attorney for the Department of Justice, Office of the United States Trustee. In that capacity, she reviewed cases for bankruptcy, fraud, and abuse, drafted motions, pleadings, and briefs in connection with presentation and litigation of cases under the Bankruptcy Code, and conducted hearings and trials. Prior to that position, Ms. Powers was in private practice with Gross Schumann Bristol, is that correct? And Gillifin, PC, representing debtors, creditors, and credit committees in all aspects of bankruptcy proceedings. Thank you all for your willingness to participate in today's hearing. Without objection, your written statements will be included in their entirety into the record, and so we're going to ask that you limit your oral testimony to 5 minutes. You'll note that we have a lighting system. When your time begins, the light will turn green. When you are 4 minutes into your testimony, the light will turn yellow as a warning that you have a minute to wrap up your testimony. And at the end of the 5 minutes, the light will turn red, warning you that your time has expired. If you are mid-sentence when your light turns red, please feel free to complete your final thought so that we may move on to our next witness. After each witness has had an opportunity to present his or her testimony, we members of the subcommittee will be permitted to ask questions subject to the 5-minute limit. So with the ground rules underway, I'm going to invite Mr. White to begin his testimony.
Thank you, Madam Chairwoman, Ranking Member Cannon, members of the subcommittee. I thank you for the opportunity to discuss the activities of the U.S. Trustee Program. We're the component of the Justice Department with a responsibility with a mission to promote the integrity and the efficiency of the bankruptcy system. Over the past 2 years, our focus has been on implementing the substantial new responsibilities given to the program by the Congress under the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. In performing our duties, we're guided by a simple principle: to faithfully carry out the law as written by the Congress, and to do so with prudence, with discretion, and with sound legal judgment. We balance many factors in every case. We vigorously enforce the law, but we recognize that not every technical violation merits an enforcement action. We work to combat fraud and abuse committed by debtors, as well as violations committed against debtors who are vulnerable to exploitation because of their financial situation. One of our major challenges is the litigation of issues of first impression. It's our duty to clarify the many new and sometimes complex provisions of BAP-CPA by bringing issues before the bankruptcy and the appellate courts to promote the coherent, the uniform, and the prompt development of case law. Another important and continuing part of our strategy to make the new law work effectively has been an enormous outreach effort with other constituencies in the bankruptcy system. We have regularly consulted with government agencies, consumer advocates, the debtor bar, creditor organizations, private trustees, the courts, and others to gain a broader perspective on our new duties. Objective evidence demonstrates that we are achieving our mission, and this is due to the extraordinary efforts of the staff of the U.S. Trustee Program around the country. My testimony outlines our activity in a number of areas. Let me now, if I may, highlight just 3 areas. First, means testing. BAP-CPA requires means testing to determine if debtors with incomes above their state median have sufficient disposable income to repay all or part of their debts. Chapter 7 cases of those who have the ability to repay are deemed presumed abusive. The U.S. trustee is required to file a statement indicating if a case is presumed abusive, and if it is, then we must file a motion to dismiss or an explanation why we're not filing a motion. Data compiled thus far show that only about 9% of Chapter 7 debtors are subject to the complete means test. Of those, only about 1 out of 10 is presumed abusive under the statutory formula. Significantly, the U.S. trustee declines to file a motion to dismiss in about 30% of all presumed abuse cases that don't voluntarily convert or dismiss. Reasons for declination include loss of employment or continuing high medical expenses, among other reasons. And we prevail in 97% of the cases in which we seek dismissal. Thus, the U.S. Trustee Program, I would suggest, has successfully enforced the new means testing law, but has done so with discretion and with restraint. Second, the new law requires the U.S. trustees to approve qualified credit counselors who are authorized to issue certificates that debtors must obtain prior to filing for bankruptcy. As confirmed in a report issued last April by the Government Accountability Office, the U.S. Trustee Program has put into place an effective mechanism to screen applicants to ensure that only qualified counseling agencies are approved. Those agencies have adequate capacity to serve debtors in a timely fashion, and they waive or they reduce the standard $50 fee in about 1 out of every 3 cases. In addition, we're making much progress in serving limited English proficient debtors. Credit counseling services are available in about 150 languages by telephone and in many languages at more than 350 in-person locations. Third, in Chapter 11 cases, we also have new responsibilities in many areas that are designed to enhance the accountability of management of bankrupt companies. Among other things, we enforce the new Section 503C, which restricts the ability of companies to pay bonuses to senior executives through key employee retention plans. Through the beginning of August, we filed approximately 40 objections to executive bonus plans and have prevailed in almost 70% of these cases. In addition, we have successfully negotiated with debtors to modify compensation schemes to avoid an objection even before the bonus plan is filed. The U.S. trustee program, we suggest, has compiled a substantial record of accomplishment. Compliance with the new law has presented significant challenges to the U.S. trustees, to debtors, to creditors, to attorneys, and others. The entire bankruptcy system is in a time of transition. The program will continue its efforts to work cooperatively with all components of the system to satisfy our obligations to enforce and implement the law with fairness, with efficiency, and effectiveness for the benefit of all stakeholders. And I'd be happy to answer any questions from the subcommittee.
Thank you. I appreciate your testimony, Mr. White. Judge Crystal, I would invite you to begin your testimony at this time.
I am proud of the bankruptcy system of the United States and believe it is the most compassionate and at the same time most effective system in the world because it goes beyond the archaic concept of looking only to the distribution of assets to creditors and offers an honest debtor a fresh start. In answer to the question, watchdog or attack dog, the answer is the U.S. trustee is not one dog. It is a pack of dogs. In the area of Chapter 11 reorganizations, the U.S. trustee staff at local levels provides extremely valuable assistance to the courts. In this area, the U.S. trustee is a beloved lassie or a rin-tin-tin. Sadly, in the area of consumers, the U.S. trustee is a pit bull. The problem comes from the top. Over the tenure of the past two directors, Lawrence Friedman and Clifford White, the policy sent from Washington to the soldiers in the field have made the U.S. trustee program in the consumer area a pit bull. I do not mean to make ad hominem attacks on Mr. Friedman or Mr. White. I respect them both as to integrity and professional talents. The problem is their perspective. Mr. White's distinguished career has been served in the office of the federal prosecutor. These gentlemen seem to view all debtors with the suspicion through prosecutorial eyes as dishonest crooks trying to beat the system and perceive debtors' lawyers as disreputable and untrustworthy. Nothing is further from the truth. In my more than 2 decades on the bench, I've observed that almost all consumer debtors seeking relief in bankruptcy are honest, decent, hardworking citizens who suffered a catastrophic financial tragedy, seldom of their own making, such as a medical disaster and no health insurance, loss of employment, dissolution of a marriage, or other financial misfortune. Consumer lawyers who represent them are generally competent and well-meaning without blemish on their character. The U.S. trustee's most recent annual report boasts of the National Civil Enforcement Initiative yielding millions in debts not discharged. There is a substantial difference between debts not discharged and debts collected. They offer no figures on debts collected. The old adage, you cannot get blood from a stone, is especially applicable here. Very little of the non-discharged debts are collected. So what has been accomplished? The report also claims that they have a better than 99% success rate in complaints filed against debtors. It fails to mention how many cases are won by default. Think about it. A destitute, honest debtor that has appropriately turned over all of his or her property to the panel trustee, except for exempt property, which in many states is meager, is served with a lawsuit filed by the United States of America, represented by highly skilled, well-paid lawyers. In these circumstances, most debtors have neither the money nor the will to fight. In many instances, their remaining exempt property will not even cover the amount of a retainer to a competent counsel. It is not Goliath against David. It is more like Goliath against an ant. And what is the benefit to society of most of these undischarged debts or denials of discharge? Without discharge and the fresh start it provides, these victims of the initiative find it difficult to get a job, get credit, or climb out of the financial pit in which they are trapped. They are denied a fresh start and the opportunity to re-enter society as productive citizens. The mean-spirited streak in the new law provides draconian penalties for the most minor and insignificant compliance failures of even unimportant matters. The U.S. trustee seems to be enamored with these harsh penalties. The new law makes it harder for consumers to save a home from foreclosure or a car from repossession, and the U.S. trustee policy seeks the harshest implementations of these provisions. Result, honest people homeless or unable to drive to work. If a debtor's papers contain minor discrepancies that would have no effect on the results of the case, there is no valid reason to persecute them. The problems of consumer debtors are only exacerbated by the aggressive anti-consumer stance of the U.S. trustee program. The independent decisions of career personnel in local offices have been subordinated to central directives from a politicized central office. while spending enormous resources pursuing minor document defects in papers filed by consumer debtors, the U.S. trustee spends little or no time on creditor wrongdoing. The U.S. trustee was supposed to be a neutral monitor of the system, and for many years it was. The neutrality that has been maintained, that neutrality has been maintained in North Carolina and Alabama under the bankruptcy administration system. A final sad example is my case, in re Jerrauld Petit Louis, a pauper. He did not own real estate. He did not own a car. He had no money and little more than the clothes on his back. He lost his job and could not pay his rent in public housing. Upon getting back to work, he was in danger of eviction because of the few dollars of unpaid rent. He could only keep a roof over his head if the debt was paid, which he could not do, or if it was discharged. Petit Louis, little Louis, could not speak English and could not obtain credit counseling in Creole, the language he understood. Of 10 U.S. trustee-approved credit counselors in southern Florida, not one had a Creole-speaking counselor. The U.S. trustee had not carried out its statutory obligation to provide credit counseling in a meaningful way. Nevertheless, the U.S. trustee sought to bar little Louis from bankruptcy relief, and when I granted a waiver, which was allowed by the statute, the U.S. trustee filed a lengthy motion to reconsider, followed by an appeal and a threat to little Louis that the U.S. trustee would appeal all the way to the Supreme Court. Little Louis gave up and voluntarily dismissed his case. Another ant smashed by the unlimited resources of the pit bull doing good as it sees doing good. I close with the words of Cicero: fear not those who do evil in the name of evil, but heaven protect us from those who do evil in the name of good.
Thank you for your testimony. I would invite Ms. Powers to begin her testimony at this time.
Thank you, members. Thanks for the opportunity to speak today. Quite frankly, it was a difficult decision for me to come here today. On one hand, I believe the United States trustees' offices are filled with intelligent, hardworking individuals who care about the mission of the United States trustee to promote the integrity and the efficiency of the system. Many of these individuals are sitting here today. On the other hand, it was my distinct feeling, based on my over 4 years of employment there, that the policies and the practices of the United States trustee were moving farther away from its mission. I felt that it was getting to be less and less about justice, and on some levels actually served as an impediment to the integrity of this system. It's that experience that brings me here to testify today. My written testimony speaks for itself. Buffalo in Western New York is a community where economic hardship is a reality, and it has been so for a number of years, most of my lifetime actually. Buffalo was recently cited as the second poorest city in America. Clearly, abusive bankruptcy filings were not prevalent. The majority of cases where inquiries had been made on our part in an effort to stem any tide of abuse, there would be notable mitigating factors. The United States Trustees program had implemented a reporting system that they called the Significant Accomplishments Reporting System. They called it SARS. It was sort of like a report card, a quarterly report card. And once I started to do that report card every quarter, it came even more apparent because it confirmed the obvious. Western New Yorkers were down on their luck. Entry after entry noted job loss, medical calamity, divorce, and a number of other unfortunate incidents. But unfortunately, that reality didn't seem acceptable in the climate of the current Office of the United States Trustee. The belief was that you must not be looking hard enough if you don't find cases of abuse. And I recount two personal examples in my testimony, and ones that in my career, may seem minor, but they did really strike home. The first is when then Director Larry Friedman came to town, and he pulled one of our inquiry files, and it was that of a retired teacher and his wife. And Mr. Friedman immediately asked where the boat was, and we weren't sure what he meant, and he said, well, all retired teachers have boats. I stated I wasn't personally aware of the connection between retired teachers and boats, but at his direction, we did a detailed document request, and he flew back into town to conduct an examination of the debtors. Mr. Friedman, he found, through his questioning, there was no intentional omission of assets. The case was eventually converted to a 13, which would have happened anyway. That's what we had targeted it for. Now, Buffalo is a small community. Lawyers cooperate with one another, and results can be achieved without putting all the parties through these rigorous hoops. We understood that sadly, the view from the top, however, seemed to be that the debtors and their attorneys were to be looked at as the opposition, and that simply was not the case, at least not in Buffalo, New York. And unfortunately, the emphasis on the numbers only became worse after the passage of the new law. I left when I realized that independent judgment was not valued or sought after in the program. I recount the example of the United States trustee in Region 2 inquiring about a garden variety case, one that wasn't abusive in any way. It just reinforced, I immediately thought we must have missed something, even though we had a multi-level screening process, but it reinforced my belief that it was all about debtor abuse. It was all about the numbers, and the micromanaging bureaucracy was only getting worse. It was hard for me to believe that someone at that level would not have something more important on her plate than that. And I felt when I realized my personal credibility and my integrity was at risk, and when one well-respected attorney in town told me that the U.S. trustee had become affectionately known in town as the useless trustee's office, and I sadly understood what he meant. On a personal level, and I also couldn't imagine spending the rest of my career looking at cell phone bills and determining if grandma was legitimately part of a household, especially when those endeavors meant very little in terms of monetary return to individual creditors. And it just seemed to me, and the reason I'm here today, is that the talent and dedication of the staff that I was lucky enough to work with in Buffalo and the people that I met from all around the country could be used to serve the system of justice in a much more effective manner.
Thank you, Ms. Powers. I appreciate your testimony. At this time, I would invite Judge Weedoff to begin his testimony.
Ranking Member Cannon, I appreciate the opportunity to be here for the purpose of offering a different perspective on the U.S. trustee program. I understand the question the committee wants to ask is whether the program has been administering the bankruptcy system in an over-aggressive manner, like an attack dog, or whether it has been safeguarding the integrity of the bankruptcy system, like a watchdog. I've been a bankruptcy judge for 20 years. I've been on a number of organizations actively that work to support the bankruptcy system, and I've presided over big cases like the United Airlines case. But the reason that I want to talk to the committee today is because of the experience I've had on the Advisory Committee on Bankruptcy Rules. When what I'll call BAPSIPA, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, was enacted, there were 6 months, 180 days, to enact a whole host of new rules and forms to implement BAPSIPA. And one of the most difficult tasks was to implement the new means test that would create a presumption of abuse in Chapter 7 cases. I was appointed as a new member of the committee to a 3-member working group to devise a means test form, to draft one for the committee. The other members of that working group were Eric Frank, who's now a bankruptcy judge in Philadelphia, but he was then a long-standing consumer debtor attorney, and Mark Redmiles, who was then the enforcement coordinator for the U.S. trustee program. The 3 of us, over that 6-month period, spent literally hundreds of hours drafting, debating, revising means test forms, not just for Chapter 7, but for Chapter 13 and Chapter 11 as well. The work was necessarily complex because the statute is complex. Our Chapter 7 means test form, as you mentioned, Madam Chairwoman, has 57 different lines over 6 pages, not because we wanted to make it complex, but because the law required that. Obviously, over that period of time, Mark, Eric, and I got to know one another really well. And what I want to convey to the subcommittee today is the very firm impression I have that Mark Redmiles and the U.S. trustee program throughout this process, not just with the means test, but with all of the considerations of the Rules Committee, were not out to attack debtors. To the contrary, the impression I had throughout this process was that they were working with integrity and fairness to read the statute properly and come up with a workable result. Now, in my written testimony, I focused on two concrete examples that I thought would illustrate the approach of the U.S. trustee program in the rulemaking process. Both of them involve the implementation of the means test and the means test form, and they both had the potential to impose significantly greater burdens on debtors than the forms that we actually use do impose. The first of these has to do with the safe harbor of Section 707B7 of the Bankruptcy Code. This makes it impossible for any means test presumption to be asserted against a debtor who has below median income. And the impact of that is that the debtor's income alone immunizes a debtor from the means test. However, there's statutory language suggesting that a debtor might have to complete all of the calculations of the means test in order to comply with the reporting requirements. And in fact, some of the creditor organizations that promoted BAP-CEPA argued to the Rules Committee that regardless of income level, a debtor had to complete the entire form. It would make a huge difference. If the debtor can complete only the income portion, 14 lines, 1.5 pages. If they have to complete the entire form, 6 pages, 57 lines. The U.S. trustee program from the beginning rejected the viewpoint of the creditor industry and asserted that the proper reading allowed only partial completion of the form by low-income debtors. The second point that I brought out had to do with the local housing standards, local standards of the IRS. These are used to determine the debtor's deductions in the means test for housing and transportation. There's a number given by the IRS. The statute directs that the debtor's deductions for housing and transportation shall be the numbers set forth in the IRS local standards. Again, the creditor industry read the statute differently. They said that the numbers that the IRS published were only caps on the debtor's actual expenses. Under that view, the debtor would have to list mortgage, rent, utilities, insurance, all of those items separately on the form and then compare them to the IRS numbers. But again, the U.S. trustees program took the position that the shorter version, the IRS number, was the appropriate one. What's the bottom line? In all of these, in both of these and other instances, the U.S. trustee program had the opportunity, had it chosen, to essentially attack debtors, to use the title of this hearing. They declined to mount any such attack. Instead, they acted with integrity, with fairness, and they helped us produce a workable result. I was grateful to Mark, grateful to the U.S. trustee program, and I have to say, heartened to learn in August that Mark Redmiles was named Deputy Director of the U.S. trustee program. I think it indicates a very positive direction.
Thank you very much for your testimony. I'm just checking, we heard bells ringing, didn't know if there is a vote. In the absence of anybody telling me that we have votes shortly, we will proceed to Mr. Uehara.
Thank you.
If you would please proceed with your testimony.
Chairwoman Sanchez, Ranking Member Cannon, members of the subcommittee, thank you for the opportunity to testify today. I'd like to clarify for the record, as indicated on my written testimony, that I'm also testifying this afternoon as a member of the National Association of Consumer Bankruptcy Attorneys, whose members probably represent the bulk of the attorneys filing consumer bankruptcy cases. My written testimony details 7 problems with U.S. trustee policies and practices. But really, those 7 problems could be summarized thusly. The Executive Office for U.S. Trustees should be managing the UST program in a way that is fair, rational, and reasonable, but in fact, it is doing things in an unfair, irrational, and unreasonable manner. As a component of the Justice Department, the public has a right to expect the Executive Office for U.S. Trustees to be fair. They are opposed to bankruptcy fraud, no one will argue. But rather than opposing fraud from debtors and creditors alike, the UST program is focused almost exclusively on looking for alleged debtor abuse, while making little effort to root out abuse by creditors and their attorneys. On a daily basis across the country, attorneys are filing bogus proofs of claim on behalf of creditors. They're filing motions falsely claiming homeowners are behind on mortgage payments, backed up in some cases by pre-signed affidavits. Debtors are losing sleep, money for attorney's fees, and their homes from fraud like this, but the EOUST acts as if only the debtor fraud is worth fighting. We think fraud is fraud and fair is fair. We also think it unfair for EOUST to have engaged in discrimination based on debtors' ability to speak English in violation of Executive Order 13166 and DOJ policy. They're refusing to provide interpreters for debtors to participate in mandatory meetings of creditors, telling debtors to hire their own professional interpreters or do without while facing walls covered with FBI posters warning of felony prosecutions for misstatement. They have stalled for years on implementing reforms. The case just mentioned by Judge Kristol is one of the most egregious examples, with EOUST attorneys having been dispatched from Washington to Miami, vowing to fight for as long as it took to have a Creole-speaking debtor denied bankruptcy protection because EOUST created and manages a credit counseling system that is poorly equipped to train debtors who don't speak English well. EOUST practices have made filing bankruptcy more expensive, more difficult, and more traumatic than it already was for consumers. They have demanded documents from debtors that exceed requirements set by law and the rules, with no consideration of the costs and benefits and ignoring the relevancy of the documents in a particular case. One example of many in my written testimony, a single mother, domestic violence survivor with two little kids, no child support, below median income, received a demand to produce proof within 11 days of all of her credit card purchases without any restriction in time for how far back the documents had to go. Many routine demands by USTs are nothing more than anti-debtor harassment. Pay stubs have been demanded of debtors who filed papers saying that they were unemployed. One UST faulted a debtor for listing herself as single rather than divorced when asked her marital status and demanded that she amend her paperwork. A U.S. trustee moved to dismiss a case after the debtor erroneously took a debtor education course instead of a credit counseling course, even though she later took the credit counseling course a day later than she was required to. UST personnel are now being sent to routine meetings of creditors run by panel trustees, apparently to protect creditors' interests, even though the creditors themselves generally do not waste their time attending these meetings. A UST attorney in Pennsylvania so harshly questioned an elderly African-American debtor about her circumstances leading to bankruptcy that she actually wet herself at the meeting. Auditors are filing documents alleging material misstatements which are neither, which will have no bearing on the case other than to cause trouble for the debtor. We've brought these issues to the attention of the Executive Office for U.S. Trustees for years, with no results apparent beyond delay and silence. Today is our hope that the U.S. Trustee Program can be urged to move towards policies that are fair, reasonable, and rational. Thank you.
Thank you to all of you for your testimony. We will now begin our questioning, and I will begin by recognizing myself for 5 minutes. Judge Kristol, you cite numerous examples of ways in which the program focuses on debtor abuses while ignoring creditor abuses. On the other hand, you note in your written testimony that neutrality has actually been maintained in North Carolina and Alabama. Can you explain the possible causes of that apparent difference?
The programs in Alabama and North Carolina are those that are excluded, are those that have been excluded from the U.S. Trustee Program under the Department of Justice. They are operated by the judiciary, and they seem to operate very well and impartially with what I regretfully say appears to be a politicized input from the Washington source.
Thank you. Ms. Powers, you stated in your prepared testimony that during your time with the program, and I'm quoting you here, little focus or training emphasized creditor abuse while you were employed there. Why do you think the program didn't focus on creditor abuse?
I'm not really certain. I just, the order of the day seemed to be debtor abuse, and the civil enforcement initiatives focused on initially substantial abuse and following the passage of the new amendments, means testing. And admittedly, I mean, it is a complex law, and for the UST to get up to speed in terms of its oversight and its enforcement responsibilities, it was all encompassing. So, in fairness to the U.S. trustee, it would have been difficult during that particular time to do much else except to get acquainted with the new law. But even before the new law, it seemed as though the order of the day was debtor abuse, and the training focused on such.
There's often a phrase that's used among friends of mine that some businesses or programs or departments are stepping over dollars to pick up dimes. And that can happen in a whole lot of ways in which things are run inefficiently. And I think, to use your own words from your testimony, that there was micromanaging and bureaucracy going on. Why do you think that is?
I'm not really certain. I think there was, again, in defense of the United States Trustee's Office, I think there was a lot of attempt to get up to speed with the new law and to have some uniform policies. So I believe that the application of, the means test and so forth was, an important focus.
In your opinion, do you think that there was maybe an overemphasis on that to the detriment of other things that could have gone on?
Well, realistically, though, I mean, that was a major overhaul of the law. So maybe it would have been nice to focus on other things, but there really probably wasn't realistically enough time. What I thought was problematic with the micromanaging aspect was the fact that I really felt as though the judgment of individuals in the field offices, the people that understood their communities best, it didn't seem as though that really mattered. I felt that was my biggest problem with it.
I think you did mention that. Mr. Uehara, you stated in your testimony that the program engages in aggressive and wasteful questioning of debtors at creditors' meetings and sought dismissal of consumer bankruptcy cases for minor alleged errors or defects. Let me ask you, why do you think the program is engaging in those practices?
Well, again, Madam Chairwoman, I think this goes back to the apparent approach that's being taken, whether stated or not, that the problem that exists in the bankruptcy system is purported fraud on behalf of the debtors, when in fact, that's not really a problem in the system today. There are lots of papers that have to be filled out. It is possible to make mistakes, but it's not mistakes that are only made on one side of the game. There are mistakes that can be made on both sides of the game. I think the point is that the system needs to be policed in a neutral way for all the parties.
Do you think that the sort of overzealousness with which they're, scrutinizing paperwork, et cetera, for minor errors, the single versus divorced? I'm divorced. I certainly consider myself single because I've been divorced for a number of years. And if I were asked to check that off on a form, I'm sure that I would put single. Do you think that that's a case of, stepping over dollars to pick up dimes? Like, so much attention is being placed on very minuscule problems that that talent and time could be better focused on perhaps creditor abuses?
Yes, I mean, that was one of many examples listed in the written testimony gathered by the NACPA membership. It does illustrate situations where questions are being asked that are insignificant, money is being extended. When a trustee requires a debtor or threatens a debtor that papers have to be refiled to correct insignificant information, which in some cases is entirely correct to begin with, that person is either going to stumble through it if they're unrepresented, and if they do have an attorney, they're going to have to pay their attorney money that they can't afford to pay for no purpose.
Thank you, Mr. Uehara. My time has expired, so I will now recognize the ranking member for his questions. Mr. Cannon.
Thank you, Madam Chair. I was a little surprised when Judge Crystal started talking about dogs, and then I realized that I hadn't read the title of today's hearing, which is whether we have a watchdog or an attack dog. I suppose that's a conclusion one has before one comes into a hearing like this. But I wanted to thank Mr. Wiedoff for his work on the rules, and I think that, given what Ms. Powers said, in fact, that we started with a difficult program. You've implemented rules. There have been a lot of changes, and the focus here ought to be, have we gotten to the point where this is working so that we don't have these anecdotes like little old ladies wetting themselves because they were interrogated too aggressively. This is not about anecdotes. This is about how the whole system is working. And I will tell you that in the process, I was chairman of this committee for 4 years while we developed this program and finally got it passed, and I was terrified of what it would do until I found myself on an airplane with a trustee who was very interesting. He talked about how these things could, this is before we passed the bill, and so when I realized who he was, I asked him how these things would actually work in practice. And we spent 4 hours talking about how it could be implemented. And I think, Mr. Weedoff, what you've done is the kind of implementation that he was talking about, and I suspect he probably had some input in the process, as many trustees would have had. But my question now is, I think the bill had the ability to be implemented. We've had 2 years after passage to implement, and how are we doing? Not are there people that had problems or defects, or maybe an individual here or there who overreached and who criticized or who required a refiling of a document because of a distinction between being single and being divorced. Those don't seem to me to be very important to this committee. What seems to me to be important to the committee is how are these things actually working prospectively. And let me direct the questions to Mr. White and Mr. Weedoff. In your experience, and recognizing I'm not talking about those situations where maybe somebody got up off the wrong side of the bed or had too strong a cup of coffee or not enough coffee and therefore was a little rough in his interrogation, do we have systems that are implementing the intention of the act, which is to balance the problem of people who use their credit cards in anticipation of bankruptcy, perhaps, as opposed to people who have bankruptcy because they have the kind of problems that Judge Crystal talked about, who tend to be honest people who have a problem in their lives. Is the system, and I suspect we're going to see it from a couple of different perspectives, but Mr. White and Mr. Weedoff, could you give us an idea of how the system has evolved, and is it actually working? Mr. White.
Yes, Mr. Cannon, I think that the systems are in place to implement the statute in an effective way. Now, it's going to be some period of time before we have enough data to know what ultimate impacts are, of course. But to turn to just a couple of the major areas where we do have some interim data, I'm sorry, sir.
And what you're saying is that it's an iterative process. You're going back and looking and trying to improve. I take it that's the essence of what you're saying.
We absolutely are doing that. So, for example, in some data that I tried to reflect in the testimony, when we look at the means testing system, we look to see not only are we filing motions, but also how are we exercising discretion in the aggregate. The proof is in the pudding. I cannot answer anecdotes that I don't have personal knowledge of that I'm hearing about for the first time, and with a field operation of 1,300 people and 750,000 cases, I can't guarantee you that there's nothing done that shouldn't have been done better. But I think we're doing a good job, and one indication is if you look at the fact that almost one out of every 3 cases that under a statutory formula is presumed abusive, we stand down and don't file a motion because we find that there are special circumstances. So we've tried to take the discretion Congress has given us so that we bring only meritorious cases. Credit counseling, which has received some attention. I recall at the last hearing where I appeared at a general oversight for this subcommittee, there was a lot of concern with regard to protecting debtors, and in part because we all knew that the credit counseling industry was a troubled industry. Congress, for example, had conducted numerous hearings finding abuses. So the last thing we wanted to do was to have the Justice Department give an imprimatur in approval of credit counselors who would then scam the very debtors they were designed to assist. So what have we found? The Government Accountability Office gave us a very favorable report last April with regard to the fact that we had an effective screening mechanism. It also helped identify a future research agenda so we can continue to look at outcomes in results. It also, though, in that report, it looked at limited English proficient debtors and are we making progress in addressing those needs, and gave the U.S. trustee program very high marks. So virtually every indicator I can see now, we continue to need to reevaluate what we're doing at all times. We need to look at the data. We need to conduct oversight of what we're actually doing in the field on a day-to-day basis. But when you stand back and you look at the forest through the trees, you see that there are systems in place, there are reasonable mechanisms, and the horror stories with regard to means testing, that it would, the terrible effects, we've ameliorated, I think, those concerns a great deal, and also with credit counseling. And I could go down a number of other areas as well. And I would also just mention, not to take up all of your time, but in Chapter 11, we have substantial responsibilities with business reorganization cases, where we've enforced the law vigorously there, too, sought independent examiners, trustees to oust management in cases where there's suspected wrongdoing, and we've been very aggressive in enforcing those provisions as well, all of which make demands on our resources. But I would suggest that the people of the U.S. trustee program deserve a pat on the back for the job they have done, particularly in the field, to make the system work. It was a Herculean effort, and we've had substantial success.
The time of the gentleman has expired, but I will allow Judge Weedoff to respond. If you could do so briefly, I would appreciate it, to Mr. Cannon's question.
I think I can, Madam Chairwoman. The question really has two parts. One is, are we implementing effectively the law that's in place right now? And secondly, is the law that's in place right now the best we can do in bankruptcy? I think as a judge, my responsibility is primarily in the first area. And I am proud of the work that the Rules Committee did. With the help of the U.S. trustee program, I think we have a set of rules and forms to implement BAP-CIPA that really is true to the spirit of that legislation and what it was attempting to do, while still having a workable format, a workable program. I think that bankruptcy is still a possibility for people who genuinely need it. Whether we can have a better system, Representative Cannon, I have to tell you, I came up with Judge Tom Small with a number of suggestions before BAP-CIPA was passed that we thought it might be able to be more effective in accomplishing its ends. I still think there are ways it could be more effective. But again, my role as a judge is to interpret the law and apply it as it's written, not as I wish it were.
May I just comment, Madam Chair, that the ability to create rules in an iterative process is much simpler than the ability to actually create legislation with many different interests. Thank you, and I yield back.
Thank you. At this time, I would like to recognize the gentleman from Georgia, Mr. Johnson, for his 5 minutes of questions.
Thank you, Madam Chair. Back in 2005, when this so-called Bankruptcy Abuse Prevention and Consumer Protection Act amendment went into effect, it upset the apple cart, turned things around, and turned them totally against debtors, in my opinion. And it was at the behest of some tassel shoe-wearing, briefcase-holding, a horde of them, lobbyists from the credit card companies and other creditors who had been extending credit to people who could not really or should not have been as aggressively marketed as they were and offered credit. And these people found themselves in difficult positions and found it necessary to do something that no consumer really wants to do, and that's file bankruptcy. It's always been a stigma, and it continues to be a stigma on people to have to trudge up to the court and file bankruptcy. That was the case pre-2005, and it's still the case now. And so it pains my heart to know that since it's become more difficult and onerous on debtors to have to trudge up there and file these papers and go through this process, that the trustees have become even more aggressive, bulldogish, if you will, about their affairs and forcing people to the point of wetting their pants. An elderly woman wetting her pants at a 341 meeting of the creditors just makes my heart cry. that these kinds of things are happening, and it was all because of these tassel shoe-wearing lobbyists for the credit card industry that forced it to happen, and the Congress went
Would the
along
gentleman
with it.
yield? Because the gentleman was attacking a process that
I'll-
I was
I'll-
actually,
I will yield.
I thank the gentleman. There are certainly credit card companies that have interests, but the purpose of this is a bipartisan bill that was an attempt to solve problems. It was an attempt to create an environment where people who are poor could have access to credit at the lowest costs.
Reclaiming my time, it was a very punitive response to a problem that did not exist. There was no fraud that was pervasive in the filing of consumer bankruptcy cases. And consumers were already being protected by the existing laws in effect at that time. And so to the extent that it was bipartisan, I have to blame both parties for ushering in this new amendment. But at any rate, I want to ask Mr. White, according to your testimony, approximately 0.63% of consumer cases are ultimately dismissed for abuse under the new means testing criteria. This means that well less than 1% of Chapter 7 cases are dismissed for abuse, even though proponents of these reforms claimed that that percent was going to be 10 times higher. Please explain the differences between those two percentages.
Well, I don't know that I can give you a definitive answer at this point, but based on the data that we do have, we have exercised restraint, as I said, with regard to declining 30% of all cases that are presumed abusive under the statutory formula because there are special circumstances, and Congress told us we could exercise that discretion. Nonetheless, we are filing motions to dismiss per 1,000 cases at a higher level than pre-BAP CPA, which would seem to suggest that the objective standard in the new statute does allow us to identify abusive cases while at the same time giving us discretion to stand down when bringing a case to dismiss would not be the appropriate thing to do. Also, what is done in the statute here is that for the first time you have, instead of the old subjective standard of substantial abuse, you have a more objective standard. What we cannot yet measure, Mr. Johnson, is to what extent having an objective, transparent standard, everyone filing bankruptcy should know that, whether they'll be presumed abusive and potential consequences of that objective finding. We don't know how many then decide not to file bankruptcy versus selection of Chapter 13 instead of 7. So there are a whole constellation of factors that are at play. So I would not. It's interesting too that at the hearing 18 months ago or so, the question was, what draconian results were we going to have because of means testing? Now the question I often receive at seminars or where I go is, does it make a difference? There's not enough of a change. There aren't enough percentage of debtors being dismissed. So it's just kind of interesting how the arguments go full circle. So what we try to do in the program is just look objectively at what the data suggest. It's very important to us. Congress gave us discretion. We would respectfully suggest that we are exercising that discretion and continue to need to exercise oversight to make sure we are exercising proper discretion. More cases are being identified under the means test than before, but we are also standing down on 1 out of every 3 cases.
The time of the gentleman has expired, and I think there is sufficient interest that we will move to a second round of questioning. So I will recognize myself for 5 minutes. I would just remind Mr. White, in the talk about statistics and numbers in the aggregate, those are made up of individual cases. So I would suggest that anecdotes, experiences that real debtors experience in going through the process do matter, and I would just ask you to keep that in mind. But the question that I wanted to ask was for Judge Weedoff, and my favorite professor in law school used to teach us laws through cases, and at the end of each case that we read, he used to ask us 2 questions, and I think you've identified at least one of those questions when you were answering Mr. Cannon's question. He used to ask us, is this a good law? And I think if I'm hearing your testimony correctly, you think that the law is good and that there could perhaps be some room for improvement, that you had some suggested changes prior to the enactment of the amendments. But the second follow-up question that he used to ask us, which I think is the more important question oftentimes, is this a fair law? So the question that I want to ask you is, approximately how many times has the United States trustee in the last 6 years brought an action in your court for sanctions against an abusive action by a creditor or a creditor's attorney? And you can give me ballpark figures here.
I can't remember such an answer, Madam Chairwoman.
You have no recollection, or you have no ballpark figure whatsoever?
No, but I think it's important to keep in mind that the statute directs the U.S. trustee program to investigate debtors.
I understand, and that's part of the point that I'm trying to make here,
I think
because I was
that's
going to say, conversely, approximately how many times in the same period of time has the United States trustee brought an action in your court for sanctions against a debtor or counsel for a debtor?
Not a huge number,
But there
have been some.
Okay, and that is precisely, you've helped me make my point. The point is, if we are going to have a law, whether it's a good law, perhaps not the best law, but a good law, we need to implement it in a way that is fair and even-handed. And I think what I'm hearing and some of the experience that Judge Crystal is talking about and some of the examples that Mr. Uehara gave in his testimony is that perhaps there has been this huge focus on debtor abuse, and the opposite side of that question is not being asked, which is
Would the
or
chair
not
yield?
being addressed in a moment, Mr. Cannon. I'd like to finish my thought, which is are creditors being pursued as aggressively as debtors are? And I would suggest that one prime example is in the mortgage lending business, and we've seen the meltdown that has occurred with these subprime loans, and the debtors trying to seek relief from having their homes foreclosed. But some of the changes to the law don't allow the families to be able to save their homes, and there are instances in which there were very little information or misleading information given to these folks when they entered into those mortgages. And I'm not blaming the mortgage crisis on the bankruptcy crisis. I'm simply trying to say that if bankruptcy is, in theory, this process by which the honest debtor who has fallen on hard times or perhaps even been taken advantage of by predatory lenders or unscrupulous creditors, have we built with the amendments to bankruptcy a system in which these honest debtors are not allowing their debts to be discharged, and they're being put through a process that, if you will, traumatizes them again and again, and perhaps in ways that don't exactly in order to the public benefit or to the public interest or to the idea of the fundamental principle of giving these debtors a fresh start. That was the conclusion of my thought. I do have one more question that I would like to ask Mr. Uehara, but Mr. Cannon.
Why don't you go ahead? I think you have a minute remaining. I'll just raise the issue when I have time.
I appreciate that, Mr. Cannon. Mr. Uehara, based on your extensive experience in dealing with language issues in courts, how hard would it be for the UST to provide translation service at creditor meetings? Because that seems to be a big problem.
Not hard at all. I filed a complaint against U.S. trustee in Philadelphia in 2003. I expected the problem to be resolved not only in Philadelphia but across the country within a matter of months. Now 2007, and I'm hoping that Director White is going to be giving us some positive developments very soon. But the process that's involved in providing language services to debtors for 341 meetings is really very straightforward.
And do you think it's fundamentally fair that a debtor who may not have great control of the English language is forced to attend proceedings in which they really don't have an idea of what is happening to them?
I think it is clearly unfair to the debtor. It's also not good business from the standpoint of the panel and U.S. trustees who are concerned about getting accurate answers to questions that are posed. And when they're encouraging debtors to proceed to testify without fully understanding the questions in a way in which they can't fully answer the questions, or to rely upon interpreters who are unprofessional and may lack language skills of their own, who happen to be present in the meeting room or relatives or what have you, It's just a prescription for trouble.
Thank you. With that, my time has expired. I will recognize Mr. Cannon for 5 minutes.
Thank you. I just want to pursue this issue that you raised and that Mr. Johnson raised and try and get clear. The Bankruptcy Act is about people getting discharged from their debts and in various forms. And yet the question has come up about how creditors are censored. And there's a way, I think, to do that in bankruptcy, but it seems to me it is not even a primary responsibility of the trustee, and I think that's what Mr. Weedhoff was suggesting. Perhaps you could help me, Madam Chair, in understanding what it is you would like the trustees to do, or what the responsibility is in the law that they haven't addressed, or what we need to do to the law to give them a context for addressing this concern.
If the gentleman will yield.
Certainly.
I didn't mean to suggest that, I, for one, have the answers. What I mean to suggest, because of the topic of today's hearing, is that if debtors are being aggressively pursued, it seems to me that the flip side of that, perhaps not in bankruptcy, but also needs to be addressed at some point, which is the abuses on the part of creditors, which don't factor into what is happening right now.
Reclaiming my time, the bankruptcy is a difficult issue with a lot of balancing here. It's not a Democrat or Republican issue. It's not a conservative or liberal issue.
I would agree.
It's an issue where you have to balance, and I think in this regard we actually have done a fairly good job, and I appreciate Mr. Weedhoff's response, also Mr. White's response. On the other hand, there are issues here that we're dealing with, as you pointed out, in another environment, although we did deal with it in the bankruptcy context, where we've had the subprime lending, I think it's fair to say scams, people who were clearly not competent to make repayments on loans that were going to accelerate the way they've done. And that's an important issue, but I think separate from the purpose of what we're doing here. And without prolonging this hearing much, let me just point out that we're in a bankruptcy hearing, we have a tool that we make available to debtors to clean up their lives and get on. That is different from a criminal environment where a person could go to jail if he doesn't have the right kind of interpreter. So while I'm sensitive to the need for appropriate interpretation, and in fact in the case of Mr. Petit-Louis, you had a person whose primary language is Creole who was in Florida, where you don't have many Creole translators, is my guess. That's difficult. It's a problem. I think Mr. Uehara has made it clear that there's something that doesn't work very well about that. But the obligation that we have here as federal legislators, I don't think is to provide interpreters, but to hope that in the implementation of the act, reason and judgment are used so that so we get the best outcome. I don't know that we want, in fact, I would suggest that we don't want to make it a very burdensome responsibility on the trustees to have the opportunity, or to have a requirement to interpret, when it is in fact, as Mr. Uehara just pointed out, sometimes difficult if you've got a relative who's not adequate in language. What are we going to require? Certified interpreters? And I think the gentlelady.
Would the gentleman yield?
Certainly.
While it's true this is not the criminal context, and so somebody's liberty is not at stake, somebody's livelihood or all their earthly possessions, or even what little property or anything that they may possess is at stake. And so I do think it's compelling when you have government action that people who are caught up in the legal system
Reclaiming my
have
time
an
is
understanding of what is happening to them.
Is the gentlelady suggesting that we should have a requirement that the federal government pay for interpreters in all cases of bankruptcy of people who don't speak primarily English?
I am not suggesting that. I am suggesting that there is a problem that Mr. Uehara has identified, and that clearly that is a problem in search of a solution. And I'm not going to be the one to suggest what the best solution is, but it's certainly a problem that he has raised and is awaiting some kind of response, because to date it hasn't been addressed whatsoever.
I agree with the gentlelady. It's a problem. I don't think it's one that we resolve at our level. But I do have another question, so we're claiming my time. I wanted to ask this first round. I apologize for not getting to it. But in your opinion, the opinion of those of you here in the panel, are the trustees being paid enough, or do we need to raise that rate? We can just go ahead quickly, and if you can opine on that.
Mr. Kennedy, if you're referring to the private trustees, the Chapter 7 trustees, they have not received an increase in their what's called the no asset fee, the $60 for most cases, in a number of years. And in principle, we concur that it would be appropriate for them to receive an increase. The difficulty is how do you achieve that? So I'm not endorsing any specific proposal, but consistent with our position in the past, in principle, we concur it would be appropriate to raise their fee.
Thank you for clarifying. That was the question. And Madam Chair, would you indulge us to hear others of the panel who might have an opinion on that?
Certainly. If they can be brief. Judge Crystal.
I served as a panel trustee when I only got $15. I enjoyed the work, but it was a charitable contribution. My partners finally made me give it up. I understand the trustees are asking for $80 instead of $60, which I think is very reasonable and still not enough, and I would highly endorse the increase.
Ms. Powers.
I would endorse it as well.
Thank you. Briefest answer we've had so far, Mr. Judge Weedoff.
I believe the trustees are very substantially underpaid for the amount of work that they're required to do under the law, but I also sympathize with the need not to increase the filing fees for debtors because that makes it more difficult for them to file their cases. So I think what needs to be found is a different funding mechanism, but the trustees' fees definitely need to be raised.
Mr. Uehara.
Madam Chair, unfortunately, as a member of NACPA, I'm afraid I have to say I'm not prepared to answer that particular question. As a career legal services attorney who's recently seen pay scales for federal employees, I can tell you we could use a pay raise too.
Thank you.
Thank you for indulging me, Madam Chair, and I yield
Certainly.
back.
At this time, I will recognize the gentleman from Georgia, Mr. Johnson, for any
Thank you.
additional 5 minutes.
Thank you. I don't think we can put this problem of the administration of the new law on the backs of trustees, because by and large, I think that the trustees are doing as much as they can with limited compensation and probably less monies in the trustee's office that is being afforded to you this year as opposed to last year. And then for those individual trustees handling the 7 and 13 cases, they get $60 per case, and that amount has not been adjusted for several years. Is that correct?
That's correct.
And then with the passage of the 2005 Act, it hoists additional obligations and responsibilities upon the trustee for the same amount of compensation. Is that correct?
That's correct.
You got to monitor these means testing. You got to do all of that additional paperwork, and you got to monitor audits, and you got to approve the credit counseling agencies and oversee all of that. And so it's definitely more responsibility on the trustees. And then, has there been, since the act went into, since the 2005 Act became effective, has there been an increased number of pro se filers, or filers who are not paying the filing fee, in other words, or has it increased or has it decreased?
To go back to your original, most of the responsibilities that you outlined are carried out by the U.S. trustees program, the credit counseling oversight and so forth, and we're federal employees. Some of the verification of income that goes into the means test, some of that is done by private trustees, but many of the core responsibilities under statute reside on the U.S. trustees.
Most of it is done by those trustees that are hired by the U.S.
The private trustees do administer the cases, but if you're talking about the change in workload, BAP-CPA, the new statute, in fact, did provide more responsibilities, and we've worked with them very closely.
But they haven't received more money, though.
I absolutely agree with that point. That point is correct. I was just trying to clarify with regard to division of responsibility.
Certainly. Has the number of pro se debtors that pay those fees, have those increased or decreased since
For the first time, Mr. Johnson, if your question goes to what you refer to IFP, informal pauperous debtors, for the first time what BAP-CPA did is it allowed debtors without means to have the filing fee waived and to pay nothing. So we don't have comparative data, because before the bankruptcy reform law, everyone had to pay the filing fee. The data that I do have show that about 1.8% of all of the filers get IFP status, meaning the filing fee is waived. And there's a mechanism in the reform law so that if a debtor seeks to have the fee waived, then they need to establish certain facts, the inability to pay, before the bankruptcy judge.
All right, let me ask this, let me say this also. In the Northern District of Georgia, in the hearing rooms where they have the 341 meetings of the creditors, it's posted prominently, signs that say FBI investigates and you will be prosecuted for this, that, and the other. And in light of the threat of possible criminal prosecution, is it, should the U.S. trustee program provide translation services at creditors' meetings to debtors who can't speak English? I know that this has already been answered, but I want to answer within that context, though.
We've tried to address that and continuing to in a phased way.
Yes or no, because my time is running out.
We are addressing, and we're planning to do more to address it, and I could go into more detail. I'm not willing to make a legal judgment with regard to the extent of the obligation, but we have a lot of progress we've made that I'd be happy to provide to you later.
Sounds like you're saying, yes, we should. And Judge Crystal...
Actually, I'm sorry, but your time has expired.
I wanted to just ask the rest of the panelists.
If there's no objection, I would ask unanimous consent to recognize Mr. Johnson for an additional minute.
Put their opinions on that issue.
The U.S. trustee has made major steps forward in the area of increasing availability of interpreters, and I commend them for that. And they're getting better in that area. And of course, in the Little Louis case and the other cases, my concern is the aggressiveness with which they pursue these uneven confrontations, and that's where I think that they should listen to compassionate conservatives and bring some compassion, or to apply justice tempered with mercy in the performance of their duties, because I think that they are too much caught up in the spirit of the bankruptcy abuse, which was a presumption before the bill was passed, and the misnomer consumer protection. They meant consumer persecution law.
Thank you, sir.
Representative Johnson, my feeling is that the U.S. trustee is attempting to make efforts to bring in translators and to make sure that people are accommodated in that way.
Judge.
Mr. Johnson, the system will work better if there are translators. There'll be more accurate answers. There'll be better understood questions. The problem is the one that Mr. Cannon pointed out, and that is paying for it. It would be ideal if we could make translating services available at every 341 meeting for every debtor who requested it. I don't know if there's funding available to do that. I would be delighted if there were.
Mr. Urahara.
If I can just clarify, and partly in response to Representative Cannon's comments earlier, the situation currently is that there is existing federal policy in the form of Executive Order 13166, which requires federal agencies, including the Justice Department, to ensure that people who don't speak English well are able to obtain meaningful access to federal government programs. The situation with the meeting of creditors and the bankruptcy counseling classes are clearly within the scope of the executive order. It's clearly within the scope of guidance issued by the Justice Department. EOUST itself, in response to the complaint we filed, issued a plan on what they were going to do to attack this problem 3 years ago, in which they had made a commitment to provide interpreters nationally at all meetings of creditors, to the extent reasonably possible, by this time. In other words, by last month, they should have been reporting on their progress on rolling this out nationally. So it's not so much a question whether it's compelled by federal statute, but it is a question that it is required by executive order and standing Justice Department policy, as well as policy within the UST program. So the other problem is that in the context of the bankruptcy counseling and what Judge Kristol was referring to, people would understand if you said, well, there's counseling agencies out there. We don't have the capacity in particular languages. We're not going to force you to go to a class that you cannot understand and cannot participate in. But instead, what they did is they said, we don't dispute that you cannot take counseling in Creole, but you didn't do it, the law requires it, and you're not permitted to come into bankruptcy court unless you do that first. That attitude and that overly aggressive posture, which violates their own policy, is what is most insulting to the, and should be insulting not only to the debtor bar, but to everyone that's concerned about the fair administration of the law.
Thank you. The time of the gentleman has expired. I would like to thank the witnesses for their testimony today. Without objection, members will have 5 legislative days to submit any additional written questions, which we will forward to the witnesses, and we will ask that you complete them as promptly as possible so that they can be made a part of the record as well. Without objection, the record will remain open for 5 legislative days for the submission of any other materials. Again, I want to thank everybody for their time and their patience, and this hearing of the Subcommittee on Commercial and Administrative Law is adjourned.